it's an association for DNA analysts and examiners. And it became very clear at that meeting in certain laboratories, what has happened is, just to be crystal clear, the DA will say, I understand the thing about the data is not supposed to be significant, and Bruce has gone into a very detailed explanation of why it's not. But they will say, but I want a new report. And so, because I don't want to speak for any prosecutors, but I'm not sure they quite feel comfortable with just a representation that it's not significant. It's better to have a new report. So they'll ask for the report, and in the process of that, the analyst will say, well, the mixture interpretation, this is a case involving a mixture, and the protocols that were in place in this laboratory when this case was originally interpreted are not the same as they are today. And two cases that were pointed out to me by one prosecutor, the result changed from either an inconclusive or cannot be excluded with a population statistic issued to inconclusive. And I don't think, but you correct me because you know, that it would change from some type of inclusion or cannot be excluded with the population statistic to excluded. Or maybe.
There are scenarios that could occur where something could be either an inclusion or exclusion. And it's another thing that, that often is missed by a number of analysts. And I don't know if you want me to explain a little bit about it, other than just leave it out hanging there.
Just while I'm catching my breath, you could.
Before you decide to resign from this position. There is a scenario that's the thing is that when people decide in a mixture, the first thing they want to interpret is, other than it's a mixture, is what are the minimum number of contributors to the mixture. And the evidence, sometimes you can do that fairly well, and as the more people you add to it, the harder it gets. Okay? So what they'll do is they'll look at the peaks or alleles and they'll count them. And any one individual can contribute 2, maximum, either 1 or 2. And if you count up and you see 4, you say, well, if any individual can contribute 2, that means there's at least 2 people in there. So then you say at least 2. Even if the evidence might be better interpreted as at least 3. But if you say it's at least 2, you have different scenarios to consider. It is 2, it is 3, it is 1,000,000, whatever you want to say. Now, 1,000,000 is ridiculous because it would just look like a big smudge. But if it's 2, there are scenarios where if the suspect is included, or his alleles are in there, he would still be excluded because you can't explain the 2-person mixture. So if the suspect, if there's 4 of those alleles, and it is 2, and he's only can contribute a single one because he's what's called a homozygote, there's 3 left over, and you can't explain the evidence as the most probable as being 3 alleles contributing from the other person. So under that scenario, he could be excluded. Now under a 3-person, he could be included, but then there's other issues you have to consider. So just by the statement alone could create a scenario where the evidence could go from inclusion to exclusion, depending on what is the more plausible explanation.
And I think I recall from your talk in Dallas, you walked the group through, this defendant in this scenario would be included if it were a 3-person mixture, but excluded if it were a 4-person.
Or 2-person.
Or 2-person, or something like that. And I may be mixing up the numbers, but my question to you was, does that get reflected in the reports? Does the end user of the report understand that the inclusion or exclusion of this defendant could be based on how many contributors there are to the mixture?
I don't think that's well appreciated in the community. It's a basic genetic understanding that should be known, but I would say that that's probably one thing that most people don't think about. But some do, I think, but many don't. So that becomes that Brady material kind of thing.
When you say many people don't think about it, what community are you referring to?
The actual practitioners in the DNA community.
Person doing
Yeah,
it.
my experience is, and I'd say, the lab we looked at clearly didn't understand it, but I've seen reports from others, and the same thing holds true. and that's not discussed. It doesn't usually come up as an issue. And probably we've never discussed it because it seemed to me so obvious. You don't, some things you think are so obvious, you don't go out teaching people, you should look at this. Then you start seeing them occurring in cases, and there's no report on that issue. So it hasn't been really thought out, but it is an obvious error in that setting. It should have been known.
Jack Rhodey had his hand up, and did you want to?
May I ask a
Yeah, let him.
Thank you. Could you explain then how that profile is interpreted differently now so that it could produce an exclusion than it was, say, 6 years ago?
Well, since it hadn't been thought of, it now should be something along the lines of, if it was a two-person mixture, then this person would be excluded. If it was, or it would favor exclusion, maybe a way to say it. If it was a three-person mixture, he would be included as a potential contributor. Now you have this issue of what it is. Part of the problem is people haven't really interpreted well because they're saying at least two, and in some of the cases I see they should have said at least three, and they set themselves up. So when they put the stuff down on the report, they set things in motion, rightly or wrongly, and that's also creates an issue in the process. So that's one potential thing where it could go from one favoring one to another. And if you look at the evidence, sometimes you say, yeah, that looks like it may favor more a two-person than a three. I can't be sure, but you have to consider the consequences of the range of possibilities.
And could you explain, please, what changed that would cause that difference of opinion now versus?
Well, that change was I don't think people were even thinking about it, but they should have. That's one issue. What's changed mostly is, for whatever reasons, is how people have been taught to do the calculation called the combined probability of inclusion. They didn't really follow it the way we who developed it were teaching it out there. They do a very blind kind of thing. It just says, if I see something and I see nothing else, it's okay. It's just sort of that thing. They don't look at the rest of the profile to figure out what other indicators there are. In this combined probability of inclusion, which you'll see as CPI or CPE approach, you have to have good data where there's no missing data. So you look at the profile, determine if it's fully represented or things could be missing. If it's missing, it has no way to calculate the missing data so that there could be an allele from a person that dropped out. So when you're presenting what is the portion of the population that contributed to this profile, you have to consider those dropouts as people who could have been in there, but they've ignored those, and those are the ones that I think where the most problem has occurred, and you have to go back, and that was some of the major problems for the Washington, D.C. lab, ignoring data that would strongly support that there can be missing data at this marker or parts of the profile. And that's where I think the most significant issue is, because then you inflate the strength of the evidence without taking the consequence of what's known about the limitations of the evidence.
I'm trying to understand with 4 alleles and 3 people, that would mean that 2 of the individuals of the 3 had a single allele in common?
There's a number of ways that can happen. One is, your example is, some have, so if you have 4 alleles and you have 3 people, you could have one person do 2, one have 1, and one have 1.
So 2 homozygotes and
2 homozygotes and 1 heterozygous.
Okay.
That's one way.
Okay.
Another way is that you could have, if it's 3 people, there could be overlapping, that they share the same one, so you only see 4. And in fact, this is another big issue with mixtures that I don't think is well appreciated, although it's been published for many years, is that you'll see labs say, we don't interpret more than 4 people. 5-person mixtures and 6-person mixtures will look more like 4 and 3-person mixtures than they will look like 5 and 6, because there are certain commonalities of population, so they will share and they'll have that scenario.
Is
So
there any way to calculate frequencies?
there are ways to do things in that, and that's part of what we have to think about as move forward, that there are better methods to accommodate for that missing data than have been used, which is pretty much you should walk away from ones where there's missing data, or at least the parts where there's missing data. And I think the problem is that people haven't walked away because they didn't appreciate that issue. And I'll probably say that most of the labs probably have cases like that at some level. Some may have more, some may have less than that. And it may be more prevalent a few years back than it is today, but it may not be completely absent today.
Do you have any recommendations for the commission with these DNL labs in the Texas?
First, I would
What
cry.
should
I
we
would
do?
cry a lot because there's going to be a lot of work in this.
Besides.
I think you need to start to find a way to first determine what kind of scenarios raise it up to an issue. Because, for instance, we've had discussions. There was a policy where if you had a major, easy-to-interpret one, some minor, they just said, nope, you don't report it. You just report because this minor here caused a throw out. That's not an error. That's a policy that didn't interpret it incorrectly and come up with a stat that would misrepresent. It was just a policy that says don't report that. Today, I would hope most labs would say, oh, I got this major and it's probative. Just treat it as a single source and move forward. The minor might not be interpreted, might be, depending on the situation. You don't want that to be flagged as an issue because it's not. That's a different kind of thing. That's a policy. Those that had this potential for the missing data will become an issue because those would have been overstated for that particular limited evidence. The one issue, and I don't know the answer to this, and it has come back to, is something that was inconclusive but could have been exculpatory, but called it inconclusive, if that is something, because we always said at the beginning from day one is, even in the areas where you wouldn't interpret, if you could exclude somebody, we would exclude somebody. That's a policy decision. Some people just say it's inconclusive and don't say anything. I don't know if that fits into something that should be raised up or not, because exclusion is very different than inconclusive. And I'd say that policies where you had it low and there could have been an identifiable profile at some markers, but you just said inconclusive, that was different than that of the suspect might be an issue. It depends on the case because the defense might have a right to consider an alternate contributor as a hypothesis. So those are the ones I think are critical. So what needs to be done, and I haven't talked about all possibilities, is things that are policy decisions that didn't affect the quality of the interpretation should be identified what categories are and take those off the table. Those that could have had an effect on this interpretation of inclusion, exclusion might be on the table. And I say might because I'm not the legal kind of person here to think about that. Those that could have substantially changed the number from, and I don't know what substantial is, to one side, 1 in a million to inconclusive is probably one you'd be worried about, right? Yeah, okay. We're on the same page now, yeah. But 1 in 10 going to 1 in 9, one side may say that's nothing, the other side may say it's a change, and we want to exploit that for whatever purposes that they deem necessary. So that's where I don't know, and I don't make a recommendation that if the number doesn't change a lot, it's okay. Because if the process was wrong, you have to go back and correct the process. Because we don't want to support that just because the number is similar, everything's okay. The consequence may be nothing, but the process has to be correct. And I think these are some of the issues you have to think about as you move forward.
That's it?
Okay.
That's all? So Bruce and I have been talking about this throughout the last week or week and a half. And it seems like I can tell you that if the commission were to start trying to help the labs work on this stuff, and these are not theoretical issues like should we go back and deal with it. These are issues where prosecutors have reports sitting on their desks right now where it did say one thing and now it says something else, and it's not a difference of 1 in 13,000 versus 1 in 13,010. It's like, inconclusive versus a pop stat. So I don't know of any other states who are tackling this issue. Bruce, do you? I mean, DC, I guess.
Well, because of what happened in D.C., every mixture case was reinterpreted or evaluated. And any situation where there was a question of that nature, and there were many other things in there as well, there were some issues, we worked with the U.S. Attorney and they made disclosure on all those cases. So every single case in D.C. good thing in DC was they'd only stood up for 2+ years and they didn't have a lot of cases, so it was manageable. When you have a situation where you may have thousands of cases, it's almost impossible in some ways to go back and do all of them. So that's bigger magnitude.
So I've been noodling over this, and I think that in order for the laboratories to really try to find the cases with, where there might be an impact of the type that Bruce is describing and where something should be done about it, it's going to require the will at the state level to really put some resources and help with that process, because these are not rarely used forensic techniques or disciplines. So in light of that, I think the laboratories, and there are a bunch of DNA folks here who should pipe up at any moment, but I think it's fair to say that coming out of the meeting, and Brady's not here, but he asked me to communicate, and Dennis is here, so he can talk about this too, but they are moving to a different type of analysis. They're not going to be using CPI anymore. So that's a big step. They're in the procurement process for the software for probabilistic genotyping, so we'll see how that works out. But they won't be using CPI anymore, but they would like to hear from the commission some guidance on what to do about any cases where there may have been a change in the report that anyone in the client community, which is the criminal justice system generally, would think is significant and could have impacted the case outcome. Part of the problem is that in 2010, SWIGDAM, which is the scientific working group for the DNA folks, issued some new guidance, and the labs over time adopted that guidance. Well, the SWIGDAM guidance says that this new way of interpreting mixtures is not meant to be retroactive. But if you're talking to the customers, who are the criminal justice community, it's very hard to rationally, as a prosecutor, I think, articulate how it could be that if a lab adopted a standard on, August 15th, that the guy whose report was done on July 15th should have a different result than the guy that had it done on September 15th. Is that fair, Jack?
Yeah, I think
Richard,
that's fair.
I don't-
Yes, sir. Yes, ma'am.
That the concerns of the client, the criminal justice system, may be different than what might have been an appropriate scientific decision, which is that we're not going to apply retroactively. The way the criminal justice system sees that question may be a little different. You think that's fair to say?
And then, I might add, is
Uh-huh.
although, I don't think that SWIGDAM should have ever made that statement, because it's not a scientifically defensible statement. They only codified what was the process that should have been in place for many years. Remember, we developed it as the FBI years and years before that. The fact that people didn't follow it, maybe because it wasn't so well codified, doesn't mean that it was being done correctly before they issued their guidelines. But there was a way to do it, and just those guidelines were the practice that should have been done all along. So it's a little bit different to go back and just say, it can't be retroactive when the process should have been in place and been known. The fact people didn't know it is a different issue.
One question. Now, we're talking about just mixed specimens? now?
Mixed.
Yes, mixtures
Right.
of the different.
Because the single, there's no problem. Mixed.
Yes.
So,
And is it all mixed ones, or the mix more than 2 or 3 or something like that? Or do we have all of them?
Well, since there are difficulties with even interpreting, but we found problems with 2-person, 3-person, and onward mixtures. Now, again, I can't say Lab X has a problem. They may have actually been firing on all pistons correctly, we'll say, but but you can't, I don't know. My guess is you'll find examples in almost every lab
Yeah.
worldwide.
So it's 2 or 3.
so in light of this information, I think we should probably put a group together on the commission to try to figure out how to approach the problem and to include, obviously, the laboratories and probably talk to people that have the resources, like at the state level, to help, if they understand the problem, they may come up with money to help support the work, because it's gonna take a lot to define the, what to do and how to do it, and assuming that people think this is something that the commission should help with, which I think is maybe a threshold assumption that you all should decide on.
I think we have to get involved.
Yes, I think
But
it's
the-
really a prevalent
yeah.
problem.
And the other question I have to ask, though, it's maybe simplistic, is what percentage of the testing is with mixed specimens?
Significant number.
These days, a very high percentage.
Yeah.
Sexual assault,
It's
so much.
transitioned
Yeah.
from the early days from more simplistic profiles.
Okay,
to
how much
high
is,
volume crime.
how much is mixed? What-
It could be
67.
60, 70%, 80%.
I'm sorry, what?
Could be 60, 70, 80% of what you do.
Oh, boy.
I really think that we should go outside and get some additional help too. Yeah.
Can I throw
Plus or
something,
minus 60, 70%.
Dan, just
That-
to
okay.
kind of maybe advance the conversation a little bit? Certainly in regard to adjudicated cases, it needs to be recognized that not all samples that might be analyzed in the case are of equally probative value. We do, I remember I worked on the Texas 7 case, where we did DNA profiles on like 60 dismantled firearms. Got crappy samples on the vast majority of them.
Yeah,
But within that set, there were several highly significant probative samples that gave good profiles. And so in an adjudicated case, the issue not to be to reanalyze all samples. It should be to identify the samples which were of value and probative and determine if there were issues related to those. But in general, I mean, I agree with Bruce on most things. I think in our laboratory, this issue of the number of contributors to a mixture has always been recognized as being kind of one of the fuzziest conclusions that we would draw from a sample. We would never do that precisely, and I believe lots of labs would not view that as a precise and number to base of interpretations on. But the other issue is that I tried to explain this issue in some regard to the Texas Bar Association several years ago. And I was met with the most glazed expressions possible. And I have never been contacted by anyone from that talk regarding this issue, and they've never asked me back. So finding resonance within the legal community was not appropriate at that time, but hopefully it might at this point.
So on Dr. Slider's point, really it's about materiality, and I don't, it's the court system, it's the court that has to decide that, and those issues can be vetted by the lawyers on the case, and they can argue about it, but it's really the court. Judge Hervey, am I wrong?
I'm already crying.
So, I think however the commission decides to approach it, will be a step in the right direction, taking the bull by the horns and bringing in whoever needs to be brought in to help with this issue that is certainly not Texas specific. The only thing that makes Texas special in this regard is the courage and willingness to deal with it head on, which I don't think you'll see. I mean, a lot of other places, they just say, well, the guidelines weren't retroactive, so that's the end of it. And I just don't see that as a sustainable position legally. So if the commission could put some people together to work on it with Dr. Bedoli, I would suggest, and bringing in other stakeholders. I see two great candidates for this sitting right over there. Bob, you can't really hide, sorry. Bob Wyckoff from the Harris County Public Defender's Office, Jack Rhodey from Galveston County. They can help us get people. Richard can help us, you know, Bobby can help. Where'd Bobby? But, you know, I think
Every time he
that-
leaves, he gets put on a committee.
So,
I think it's a great idea. I think
Yeah.
we should give guidance and support.
I think we have to form
Advisory group.
an advisory group, right?
Yeah.
And, well, first thing we have to do is someone has to make a motion to form the group. Someone gonna make a motion?
I make a motion for the.
Well, he got ahead of you.
Okay.
So, will you second it?
I second it.
Okay. Aye?
Aye.
Nay? Unanimous. Now we have to get people on the group.
What's a guarantee Bobby's gonna be on it, because he left the room.
well, I mean, we have two DNA experts.
Well,
sitting
that's what
here, you know, so.
I was trying to be real polite about it, you know?
I strongly
happy to sit
suggest
on it.
that Dr. Bedoli be asked to be on this committee if he has the time. He's very busy, but this is really important, and the state could really use his assistance. I think he's very familiar with many of the state labs, some of the things they do right, some of the things they do wrong.
Well, we don't have, we can just appoint the people from our group, and then they can get the assistance
Yeah,
they
I think
feel.
Dr. Bedoli's assistance is
It's vital.
absolutely
Absolutely
vital,
needed.
and we just have to figure out how to support that financially,
Right.
really,
Okay.
with the university.
Right,
Um,
absolutely needed.
so,
Um,
do you have anything to say about it?
didn't know the commission could just pick a citizen off the street and appoint
You're not just a citizen, and yes, they can do it.
But,
If Lynn says we can do it, we can do it.
no, we can't do that, but we can, I mean, you can have an advisory committee that has non-commissioners on it, but I think as a core matter, there are commissioners who need to facilitate the process of bringing those people to the table, having the conversation, starting the process. So I keep looking in this diagonal direction.
Well, do you
Yeah,
want
we're
to
happy to do that.
have someone nominate people from our commission?
I volunteered to
Yeah,
be
and
part
I'll
of it.
volunteer.
Okay. So we have 2 volunteers. Do we,
I think we have to have at least one prosecutor, if not like 6. Richard?
we have Richard?
Yes. And defense?
And defense,
And
maybe.
Bobby's-
Bobby is out, you can put him there.
Right.
That's a
He
good time.
volunteered.
But I think in addition, we need other people from the community as well.
Right, I agree.
But it's sort of like the same way we do hair, where the hair people are not commissioners and they advise the
Right.
panel.
Yep.
What about,
You're talking about
All right.
medical?
I guess you,
Jody, you
some,
should get on it.
Yeah, oh, no, I waved my hand. I've already hit you up on one of them earlier, so.
I'm a little out of date with my DNA, so,
okay, so,
not the personal DNA. Well, even the personal DNA is a little out of date, too.
so Eisenberg, Hughes-Stam, Lerma, Albert, Bernard.
Great.
Okay,
I think you have your hands full for the moment.
Yes.
so, you wanna,
When we can draw one.
someone wanna nominate them? Do we have to go through that, or
I
just,
think just make a motion to,
Make a
to
motion
nominate
then.
them?
okay? You made it?
Yes, I did.
Second? Aye?
I,
Nay?
okay. All right, so we'll get that rolling here soon.
Because I think one thing that came out of AFTA after Bruce gave his talk was in the room with all the crime lab directors is that there is quite a disparity
yes.
of need in the state. And so some labs are going to need a lot more help than others.
Mhm.
And so I
The-
think that's vital to be able to identify.
The judge wants to say something.
Yeah, Judge Hervey?
I'm gonna ask our general counsel and the rest of the court if we can be of assistance in helping you secure funding
Oh,
for
that'd
this
be
project.
great.
And I think it would be a really good idea, you guys do great work. I think it would really be a good idea for you to get ahead of all of this by putting out information so the legal community knows you're working on it. Okay, so so they don't drag you down by saying everybody's ignoring it, okay? Because it's out there already that this is a situation, but if you can help yourself and help the legal community at large by saying you're working on it. So they know you're not.
Okay.
And
Yeah.
that will help hopefully the legislature know that they need to help you too. 'Cause
So
it'd be a big
I think
deal.
we need to make better use of our website for things like this. And I did do a 2-page write-up that I worked real hard on and hopefully is a decent articulation of the issues. And Bruce checked it for me, so I feel like it's in decent shape, right? The 2-pager. So we'll put that on our website and we'll put just an announcement that the commission's gonna tackle this issue. And that's really, I mean, that's the first step, right? I mean, you gotta start somewhere. Thank
What
you.
is,
And
what does
when
the DPS need to make the transition?
Well, we're already in the process. We've got new SOPs
Right.
that just went into effect August 10th. We've already started the procurement process for some probabilistic genotyping
Right.
software back in March or April or sometime earlier.
You have the money for that software?
I think we do. I
Okay.
mean, we don't know what it's gonna be yet because we can't say we want this specific
Right.
thing. So we'll have to see as the process goes forward how much that's gonna cost us. But I think the agency's got a commitment to moving forward in that direction. So we're gonna be going forward. We'll be putting out what do they call it?
Request for proposal?
Request for proposals,
Right.
and we'll get some proposals and start evaluating whatever's offered up from the vendors, and then start evaluating their products. So that
Okay.
should be happening this fall.
Thanks, Dennis.
That'd be great.
Okay, so, do you wanna move on, Dr. DeMaio?
I think so, right. We're gonna have lunch at 12, so
Okay, well,
we can start.
you said we're gonna have lunch at 12? I might be able to get through hair microscopy.
The what?
Keep going.
Maybe not. I don't know.
Do something smaller.
Well, I have a PowerPoint to do for that.
Well, I mean, why don't we just start the cases?
Okay, yeah,
Because
that's,
we might be able to go through them fairly rapidly. Okay, I think Dr. Eisenberg is.
Okay, so we had roughly 6 new cases to consider, and the committee met yesterday at 4 o'clock. Committee being Mr. Alpert, Mr. Bernard, and myself, along with Dr. DeMaio was present and some others. And we had a discussion on some of these. Some of them we thought were pretty simple, but may turn out to be a little more complicated. So let me put my glasses on so I can do some reading. Oh, so the case numberings have changed slightly. So the case is now, the first case to address is case 1106.15.03. A complaint filed by Mr. James Taylor, recently resigned from the Pearsall Police Department, expressing great concerns regarding evidence storage, handling, and preservation by the city of Pearsall, Texas. Is he here?
I don't know. Is Mr. Taylor here? No, I guess not.
Okay.
Okay.
So the concern was that Pearsall County basically abandoned the way that they had been storing evidence. There was chronic negligence by the former administration police department, and the former police department abandoned the facilities that they used for storage of evidence, and the case has been exposed to public urination, and they were severely compromised. These were both sexual assault kits, narcotics, and weapons. He included pictures of this, and we were very much surprised at the quality of the pictures, what they showed. The building was basically abandoned. There was no security controls. Trespassers were not excluded. So Mr. Taylor alleges that along with the vandalism of the evidence, multiple pieces of evidence have been gone missing. He further alleged that the city manager was made aware of this situation, but did not offer any assistance to doing this. So his complaint is that he's really very concerned about the lack of quality of evidence storage and maintenance, and he wants to see if anything can be changed. So the committee met, and we felt that the commission doesn't have jurisdiction about this complaint because it involves local law enforcement evidence storage practices that we have no control over, not the forensic analysis, although clearly the forensic analysis would be compromised in many situations. So the recommendation was that we consider we're not dismissing it because we don't think it's important. Let me just say that, and first of all, we're making a recommendation that the commission be allowed to contact potentially the Attorney General's office, the Rangers, or any local DA that might have greater authority than the commission does to intervene in this particular effect. But because it's not under our jurisdiction, we suggest that we don't want to dismiss it. We want to essentially pass it on to those who could possibly use that information. We think it's a serious complaint. Based upon the pictures, it looks like it's a serious health issue. Certainly it compromises evidence, but not any particular case. So that's our recommendation.
If we don't dismiss it, we are obligated to investigate it. So
Right.
if we dismiss it and we refer it to the AG's office.
Yeah, I think that's what you mean.
Yeah.
Yeah.
Yeah,
That's what you
We
mean.
are recommending we dismiss it, we just are recommending that staff
Exactly.
forward the information to the AG or the Texas Rangers for further investigation.
Plus the health department too, since there are biologicals
Yes.
apparently being
And
exposed.
based upon the picture, clearly it shows biologicals being destroyed.
And I have no idea who's in charge of that outside the local city authority, but we'll try to contact people and see.
Yeah, I don't have any idea either.
OSHA maybe, no?
So
Yeah,
I
well,
think we-
for the biologicals, yeah.
Right. So I think we have to make a motion that we're,
Motion to dismiss.
we're dismissing our
Involvement.
jurisdiction on this, but we're going to notify other people who might have some supervision over this. Someone want to make a motion? Second? Aye?
Aye.
Nay? Unanimous.
Okay, the next case is case 1113.14.28. The complaint was filed by inmate James Legat alleging a trace evidence analyst in the Bear County Crime Laboratory used misleading language in expressing their conclusions regarding gunshot residue analysis. Essentially, what had happened was that, let's see. Maybe I turned too many pages. Yeah, okay. So, right. The language that the, Mr. Legate had accused the Bear County Crime Lab was that their analysts used the word indeterminate in terms of the evidence. That is, they could not detect the presence of gunshot residue. And the question was, is indeterminate a factual statement that allowed the prosecution to mislead the jury? And according to the scientific working group, SWIG guidelines regarding gunshot residue analysis, using scanning electron microscopy, that was certainly a legitimate classification. Doesn't mislead the jury, it simply says indeterminate means they could not detect the presence. Therefore, they could not say one way or the other if this individual had fired the gun. And the committee felt that the staff does not believe that this complaint has articulated a basis for conducting an investigation of professional negligence or misconduct by the laboratory based on the examiner's use of the word indeterminate. It was an acceptable terminology, and that we probably should dismiss this complaint. So that's the recommendation the committee is making to the whole commission.
Now, I have to excuse myself.
Yes, sir.
Because it's Bear County, so it's,
But the bottom line is they tested, they swabbed him for gunshot residue, it was negative, and in the report, they say that, and they also say, whether he fired the gun is indeterminate, and that's true.
Right.
Right, so,
We never report negative in any report, it's always indeterminate.
Do y'all have anything else?
No, you've expressed it accurately.
I recommend we
That's the right
dismiss it.
way to report.
That's the
So
way
I
you're
make a
supposed.
motion
They
to
do it
dismiss
even
the
today.
case.
Okay, which is your motion or your motion?
It doesn't make any difference.
You make a motion, I'll second it.
My motion is we dismiss it.
I second.
Someone else is gonna have to say it,
You have to
Yes.
call it to vote.
All in
Can we
favor?
call this to vote, please, by the full commission?
except for me.
We have a
He
motion,
moved.
we have a second.
Yes.
All in
those
favor?
All in favor of?
Aye.
Any opposed?
One extended, but everybody.
One abstention.
Okay, one abstention. All right, the next complaint, 1122.14.31. This is a complaint against the DPS for a forensic analyst falsely testifying in information involving the presence of benzyl
Ecocnine.
Benzoylecgonine.
BE, a cocaine metabolite in the complainant's blood. Okay, so this individual was pulled over at a red light for driving erratically, and they thought that there was one of the EMTs thought there was a smell of alcohol. Her blood was drawn at the request of the hospital and was tested for alcohol. No alcohol was detected, and the state requested testing for drugs. The test was positive for cocaine, as we've heard from Lynn, who read the information. The Department of Public Safety Forensic Toxicologist Renee Hawkins confirmed the results with a second test, which showed traces of BE, a cocaine metabolite. BE can only enter the system by consuming cocaine.
Well, it's a breakdown, really, of,
Yeah.
like,
So-
I think the way I wrote that's not really
So
right.
it's not the right way. A little,
It's,
we need to
it is,
change it a little.
cocaine is, this is me telling, I'm sorry for that. I think that's not right. It's not that B enters the bloodstream, it's that you
They use
do the cocaine and it
Cocaine
breaks
enters,
down
right,
into.
breaks
metabolite.
It breaks down,
Right,
it's metabolized, and BE is one of the breakdown products. So the amount of BE detected was 1.4 milligrams per liter, and then the results was sent back, the sample was sent back to the police department, where it appears to have stayed at 10 months at room temperature, which is not conducive to maintaining the BE. The BE probably broke down. The samples were then sent after 10 months of sitting at room temperature to NMS Labs at the request of the Defense Council, not the laboratory, and where it was tested for cocaine and cocaine metabolites. They did not identify any cocaine or cocaine metabolites. So the complainant alleges that DPS lab falsified the report to incriminate her, and the NMS laboratory report containing negative results were never released to the trier of fact. Not the fault of the DPS. But there was nothing detected after 10 months after sitting around at room temperature. So
You want to-
the suggestion is that there's no specific example or lecture, alleging that the DPS did anything wrong about it. So the committee felt as though we support the decision to dismiss this case.
I think the discrepant results between what DPS found and NMS are not, they don't raise red flags because of this breakdown issue with the BE. Is that, but
What is happening with the DPS, they test them 2 times.
Mhm.
So one time for the screen and was positive.
Right.
For the cocaine groups, metabolites or whatever you say. Then they did it specifically by the mass spectrometry and they find the benzoylecgonine.
Mhm.
And then after 10 months, if it's in the room temperature, there are many literature that says, indicate that the BE might be all degraded to
Mhm.
nothing. So,
I think the point
That's
is
it.
nothing, it does not degrade to cocaine.
no, they don't get to the cocoetylene or
But the living
ecocnine
person
or
will
any
have
of those. Those are something else, So the report needs to be a little changed to be right, but that's, the conclusion is
Yeah.
okay.
Correct.
That's
well,
right.
I'll point that language came from an email from DPS, so I'll talk to them about
No,
that.
No, that's, yeah.
cocaine requires a living person.
Yes.
It happens in the liver, and you gotta have alcohol present. If there's no alcohol, you
Yeah,
So this person tested negative for alcohol, so there's no way he could have, it could break down to cocaine.
and he didn't do, but that's, the reason was that I guess this person, it's a lot, because I think the blood actually came from hospital, and I'm pretty sure probably sodium fluoride was not there, so the whole cocaine, if it was there, was, converted to the BE before it gets to the DPS. So that's probably even the testing of the DPS was in favor of the defendant.
And they did find trace amounts of cocaine in the
Right.
blood, but that's not, that I know because I read the appellate decision, not because it's in the complaint, but they did find that
Yeah,
as well.
so-
And there was actually a big issue with the Court of Criminal Appeals because the amounts were traced and they couldn't, under their SOPs, issue a report indicating that, but they testified to that effect. So there were questions about whether that's okay.
So,
And it might have been more than trace had it,
Yeah.
had the right tubes. I don't know that it didn't, but if
yeah, I don't
they
know.
did not, then the result you got was not really demonstrative of what they had at the time they were specimens
And
taken.
the amount is so insignificant, 1.4 nanogram per mil to begin with, and 8 months have passed, it's totally.
It's gone,
insignificant.
yes, and that's, yeah.
So the committee recommended that the full commission dismiss this complaint.
I so move that we dismiss this complaint.
Any seconds?
I second it.
Okay, so we have a motion and a second. So the question is,
Question is the vote.
the vote.
Aye. How many aye?
Aye.
Nay?
Unanimous. Okay, so the next complaint is 1123.15.06, a complaint by defense attorney Deandra Grant alleging IFL, blood and alcohol analyst Nate Stevens failed to follow IFL standard operating procedures when retesting blood samples and issuing reports on those samples.
Do we have enough people with the two people?
So we have,
Yeah.
Shows and we're missing Bob.
well,
So-
if you abstain, you still count toward the quorum.
Okay, okay.
Okay, so I have to recuse myself because in this particular case, Ms. Feller, Elizabeth Feller, was an analyst who allegedly was involved in the testing to some extent, and she's a former student, and I feel as though it's not fair for me to participate. Richard Alpert had to recuse himself on the committee because it's the Tarrant County case, and
I was the last man standing.
so,
We have enough.
Yes.
so we wanted to make sure, rather than give you any more information, that you've probably read the information and you come to a decision.
So just to walk folks through this, Elizabeth Feller came to IFL from another laboratory. At a certain point, it was the DA's office that learned the circumstances surrounding her termination from the other laboratory, and that, from what I understand, involved what they call a failure to follow protocols for the prevention of transfer errors and switch samples. So when the DA learned that, they decided they were not going to sponsor her as a witness anymore. And because of that, of course, that means she can't fulfill one of her fundamental employment duties, which is to be able to testify in court. And so she was let go from IFL. So then the question became, what do we do with the cases that she worked? And when I say worked, there are actually two different types of cases. One are cases where she picked the evidence up, tested the evidence, issued a report. She may have done the whole thing soup to nuts or some, but she was involved in the physical testing of evidence. There are other cases where she interpreted data and perhaps testified in court with respect to that. At some point in the process, IFL and the DA's office communicated about what the policy should be for reanalysis of casework. And it was decided that for cases where Ms. Feller had ever touched the evidence, she was in the chain of custody, all those cases would be re-examined, physically re-examined. For those cases in which she provided data analysis or interpretation, those cases would be reanalyzed or reinterpreted, not reworked from scratch, because she hadn't touched the evidence. That was communicated to the DA's office, and through emails that we received from IFL, it demonstrates clearly that that was communicated to the DA and that they understood that. The DA sent out a Brady notice with respect to this, so I think the defense community became aware of the issue. And at some point, I think people in the management and the DA's office realized that some of their ADAs didn't fully understand what was happening. So they may have thought that everything was being retested, or maybe they didn't expressly distinguish between retesting and reanalysis when communicating with defense lawyers, and the defense lawyers were under the impression that everything was being retested. And so there is clearly a communication gap between what was understood and communicated by the laboratory and then by the DA to the local defense bar. The challenge is that the defense community, understanding the cases were being retested, made certain decisions and recommendations to their clients about whether to take a plea or not, what type of plea, et cetera, because they thought that the new reports, so the old reports had Elizabeth Feller's signature on them, the new reports had Dr. Nate Stevens' signature on them, and they're called supplemental. But they don't distinguish expressly between those cases that were re-examined, and by that I mean physically the evidence was re-examined, and those that were re-analyzed in the sense that the data was interpreted. And so the complainant has real concerns about the way this all has worked out. I think she was originally under the impression that Dr. Stevens was just signing the same report without having done anything else, which would essentially amount to a misrepresentation about what he was doing. But I think that the IFL has clarified those issues, and we do have representatives from the laboratory there. Did I say that accurately, do you think? So I think there are a couple issues. Number one is something that is unrelated to the commission, which is communication about what's going on in cases like this. I mean, if that miscommunication happened, I think Larry Moore tried to clarify to the community what it was and actually accepted responsibility that, maybe we weren't clear enough in his letter dated June 11th. He says, it appears that not all of the attorneys in our office were aware of the above described procedure being utilized by IFL, so it is quite possible that some were indicating that blood would be retested when in fact the results were only being reinterpreted. I therefore understand how this could lead to confusion and to the concerns expressed in your letter. So that kind of sums that piece of it up. The only outstanding question in my mind, and I don't know, I mean, Dr. Mosiani, you'd probably know this better than anybody, but the real question for me is, so you have a report with an analyst's name, and then you have a supplemental report with an analyst's name. Should there be more information in there?
I was saying both of these reports, and the lab, I think IFL did the right thing. They didn't need to retest them because sample, and they need just to go and just look at the data and issue the supplement report. But they needed to have it more information in it to say what has been changed, because at this moment, they don't, it looks the same to them, so they don't have any information. And supplement report has to say why that was the change, was it, or mention a little about that. And hasn't did that.
Should explain why.
Yes, or amended report, either was, what has been changed, this is amended to the report of the before, so that part is missing in this
It's a failure to
report.
communicate.
Yeah,
That's
so
it.
again, better communication in the final report.
So maybe how would you suggest we resolve it? Should we write a letter to the laboratory making suggestions about that issue, or what do you think?
I think that any laboratory or any report, or even our type of report, if we amend it, we explain why we are amending it and what is the purpose of this amendment. And they failed to do that. They published the report, and they basically had the same thing exactly in the new signature, and this is a bit confusing. Yes, we have to point out why it is that. And the DA's office has some responsibility also. in the
Can't even
sense
speak,
that
right?
They should have been more clear and precise. They shouldn't assume that the assistant DAs fully understand the difference between this word and that word. And I think that's the other area that we should perhaps send a letter out.
Why not send a letter to the laboratory and say, in instances where supplemental reports are made, it should indicate on the report that this is a supplemental report, and state the reason why. That's our total action.
It has the word supplemental.
But not
It's just that that it's hard to know
You don't know what it
What
means.
extra work was
you
done.
know.
why, what
You're-
was done.
It's not going to a scientist, you know what I mean?
Mhm.
So,
It's just a very simple miscommunication.
just there,
Yeah.
no big, nothing. Do you want to make them,
We have a motion in this particular case?
well,
I'm not
You're-
allowed to say that.
oh, come on.
We have a motion to this, for this case, to write the letter to the laboratory and request for them to start to mention why the supplemental report has been issued for their cases. And beside that, we dismiss the case. That's right.
Okay. Second?
I second it.
Aye?
Aye.
Aye. Nay? No.
Okay, we can move on to the fifth case, which is 1121.11.15. By the way, there was some mention of going back to the old way in which we named cases.
Well, you don't have to read that number
Well-
all out like that.
This complaint was by Curtis Adams alleging various inadequacies and misconduct by investigators and forensic analysts in his sexual assault case. Okay. Mr. Curtis was convicted of sexual assault in 1987. His complaint alleges various problems regarding the investigation and prosecution of his case. He does not state any allegation of negligence or misconduct against any crime laboratory, absent a blanket assertion that the forensic analyst lied in the stand, saying DNA was conducted when it was not. So there was really nothing specific about any laboratory process claiming negligence or misconduct. So since there was nothing specific, he's just complaining that there was misconduct relative to the forensic analyst. The complaint raised issues regarding the investigation and prosecution of his criminal case, but better suited for vetting by one of Texas Innocence Clinics. So as far as the allegation, the committee voted to, that we felt as though since there was no specific allegation, we decided to not deal with this particular case and make a recommendation and pass his complaint on to the Texas Innocence Project.
Or to any of the innocence clinics. We
Right.
have a list.
Just have to excuse myself, Bear County.
Yes, please, thank you.
So, do we have any motion by the commission?
I move we dismiss.
There's a second? We have a second? Thank you. And any vote, yea or nay? All in favor of dismissing, vote yea.
Yes.
Yea.
Nay?
Any nay? Nope, so it's dismissed.
Lynn?
Lunch?
It's
Well, we
out
have
the
one-
hallway, yes.
Okay, we should take a break.
Yeah, because
Okay.
this one's gonna take a while.
This one's gonna take a while.
Yes.
I don't know why you think that. I think it's gonna go quick.
Well, I could.